Hi, everyone. This is Caroline Griffin. I am the Event and Operations Manager for Riot. We were so excited to have Michael and Igor here from Tarolli today to give us a deep dive into patent law. They are joining us all the way from Cleveland, so we're super excited to have this virtual event. Just a couple housekeeping rules before we get started. If you do have any questions, please put those in either the chat or Q&A box, and we'll make sure all of your questions are answered. This video recording is going to be recorded and made available on Riot's YouTube channel and will be posted to the Meetup page. So look out for that later this week. And all of the participant list is hidden. You are not the only one here. You just can't see anyone else to protect everyone's privacy. But without further ado, I will give it away to Michael and Igor. Thanks for joining us.
Thank you, Caroline. Welcome, everybody. I hope everybody's having a good afternoon. This presentation that we would like to focus on is kind of a deep dive into what happens after you file or submit a patent disclosure with a law firm that you're working with. The agenda today, we're kind of initially going to start off briefly about our introductions, then talk about, kind of give a backdrop, what is a patent, so everybody's kind of on the same level in understanding. Then we'll focus mostly on the patents in the U.S. system, and then transition to foreign patent filing, things to consider, how you should proceed in certain business strategies, and the last section is kind of, we'll wrap it up with questions. If anybody has any questions during the presentation, I believe there's a feature to submit questions.
Yeah, Caroline just talked about that. So one of the things that I want you guys to all come away from is, like, we're going to be telling some interesting, at least I think they're interesting stories about particular patent examiners and cases we work with. Understand that these are kind of outliers, and we've worked on thousands of cases. We're just trying to make this subject matter can be a little dry, so we're trying to add a little color. That doesn't mean, like, if you file a patent application, you're likely to come across some of these ridiculous situations that we've seen. But just to make things a little bit more interesting, we're going to mention some really weird cases. So
thanks, Mike. So a little bit about our firm. So we work with all types of clients. Majority are Fortune 100 companies, as well as universities and startups. We kind of provide a list there, including Oracle and Northrop Grumman and Cadence and Cleveland Clinic. A little bit about the firm. We have about 30 patent attorneys. So the way we're structured is each tech group is attorneys with the specific technical backgrounds. For example, if your invention is a computer-related invention, you'd be working with somebody who has a background in electrical engineering and computer engineering. A little bit about the various types of technical backgrounds we have there, as Mike showed, including biochemistry, organic chemistry. A lot hold advanced degrees. This is a little bit about Mike here. So he graduated from the University of Cincinnati with a EE degree. He's worked, I believe, 10 years, Mike, right, in the IT field.
Yeah, just about that.
So he started with the firm, and he's been here the whole time. A little bit of interesting facts about Mike. He's basically the go-to guy in terms of random facts. So if you want to know some random facts, he's the guy to go to. He has extensive experience in PTAB practice. That's the Patent Trial and Appeal Board. That's what happens if you're during prosecution, you get a final rejection, you decide to appeal it. You would go to appeals board and you'd write what's known as appeal brief. Mike has special expertise in that, as well as we also have, Mike included re-exam practice, which is kind of a third-party review of an issued patent. A little bit about me. I also have a EE. I worked prior to, I guess, switching careers as a EE in the tire cord industry. I actually joined the law firm and worked full-time during school, and my practice is very similar to Mike's, focus on computer and electrical engineering. So kind of starting first off, as I mentioned, what is a patent? So a patent is a property that provides a right to exclude others. So it's not a positive right, it's a negative right. So it prevents you from having other people do something with your intellectual invention. It's essentially a defensive right, and it is a monopoly over your idea. to get a patent, you have to publish it and provide an enabling disclosure. So these are kind of, we highlight these terms in blue. What does it mean to publish? Essentially, you have to make your invention, the description of it, publicly available. So, and you also have to disclose the best mode. One of the interesting things is the law's kind of changed regarding best mode, which is basically the best way of practicing your invention, is even if you fail to disclose it, there's really no way to challenge the validity of a patent gets issued on. However, if the USPTO, like the examiner, learns about, that you failed to provide the best mode, they can actually prevent from issuing a patent.
In our practice, between the two of us, we've had maybe 5,000 applications. Yeah. I think I've seen a best mode rejection once in that entire time, and that was basically a situation where we didn't mention, or the inventor didn't mention, that you could use a fiber optic channel instead of a copper channel, and they just allowed us to amend the specification. So it's almost never a bar to getting a patent.
Right. So, and as I mentioned, the other, I guess, key requirement for patent filing is your disclosure has to be enabling. So it's really the best way to think is like a fancy term that says that, hey, you have to provide enough information sufficient that one of ordinary skill of the art, which is essentially a hypothetical person, would be able to read your disclosure and create the invention. So this doesn't mean you have to essentially describe, you can say, the nuts and bolts of the invention, just enough so you can implement the invention. So I guess you probably are wondering, well, how much is enough? And it's really a balancing act. There is a test called undue experimentation. Basically, questions to ask is, have I disclosed enough that where it's not going to require essential, experimentation beyond reasonable means to create the invention? When preparing kind of a patent application, it's best to show the enabling disclosure by way of an example, and highlight the advances the example makes over the prior art. Here's kind of another way of considering what a patent is. It's essentially a deal, and you're striking a deal with the patent office, and you're saying, hey, I'm going to give you, the invention, describe it, and make it available to the world, and you're going to give me an exclusive right from others from manufacturing, using and selling and importing the invention. Just kind of a key note regarding importing the invention, there is a special, basically, court that handles this types of litigation matters, and it's known as the International Trade Commission. So, for example, if you want to prevent another party from bringing in an infringing product, you would go to the ITC court and you would litigate it in that jurisdiction. It's worth noting that it's kind of a very fast process. So from starting a case to ending, it could be as fast as 18 months.
Well, just a quick story on that, just because I know Tom Snyder is a woodworker. Certain he's familiar with SolStop. They were able to use the ITC to stop Bosch from importing a competing product that had the safety mechanism. And even though they had patents on it for 20 years, they didn't sue for infringement. They just stopped Bosch from importing it, and it really sped up the entire process. And ultimately, that was what led SolStop to being sold to a higher bidder because of the value of the IP.
Mike. So as I mentioned, patents can be essentially sold, licensed like any other property. For example, like a car or a house. A really good example I would consider a patent similar to like a house, Airbnb. You can control which part of the house it gets used, how it gets used, which is kind of similar to how a patent, you can control how it's used in which industry, in a particular industry, as well as the licensing allows you to provide an exclusive license, a non-exclusive license. So probably a good takeaway is that licensing plays a critical role, for example, in startups, which can be essentially a substantial revenue in fueling in funding the company. By way of example, I'm not sure if anybody's familiar, it's a company called NU Current, which is a startup, has licensed wireless technology to Apple and Motorola, which has generated millions of dollars in revenue for them. So I think kind of one of the funny things, everybody thinks that everything should be patentable. That's not true. You should not patent everything. So And these kind of two examples kind of highlight this. You have this example on the left there, which is basically how to train your cat with a laser pointer to do like, you know, exercises and stuff. In my opinion, this patent should have been granted. It was granted in like early 90s. And if you essentially have a laser pointer and you make your cat chase the dot, you're infringing that patent because it's still enforceable. Nobody's actually challenged it, and I don't think the patent owner's probably trying to enforce it anyway.
It's expired by now, but
yeah, and there's been actually a couple other patents that were granted on cat exercises similar to this one. Over the years, the patent office wasn't perfect in the 90s, but it's in contrast to now, it's more, I would say, it's more sophisticated and it has substantially improved. And then you have the patent on the right. I'm sure everybody's familiar with global positioning systems. So that's essentially the first patent. That's something, yeah, you want to get a patent on because we use GPS almost in every you know, mobile device now has one. And continuing with the next slide. So there's two types of patents you can get essentially. There's you know, a utility patent and a design patent. Utility patents gives you a 20-year term. By contrast, design is 14 years. Utility is basically a patent on the use of the, you know, the invention. A design is basically the ornamental patent. So a good way to, you know, to envision a design patent is actually the French designer of the Statue of Liberty there actually had a patent. It was a design patent, which overlooks, you know, the harbor. I think it was since like the 1880s. So, and it basically, like I was mentioning, it protects how it looks.
It's important to note that a lot of times you'll see a patent application that's you'll see two different applications in the same thing, one a utility and one a design, because the design patent only covers the non-functional part of the invention. It's like how good it looks or something like that. Because we get that question a lot with design patents. Well, it works in a certain way. If it works in a certain way, then it needs to be a utility patent. So the next thing that you get the question of is, well, you know, once you've decided to go through with this process and you decide to, let's say you're going to go with the utility patent, how do you get one? There's three major stumbling blocks that you face when trying to get a patent. The first is 35 U.S.C. 101. Is the very essence of what you're trying to patent, is it eligible to be patented? It used to not be an issue at all. It used to be that practically everything was going to be eligible for a patent. But in the last 10 years, both medical and software patent applications have come under great scrutiny for being directed to what they call abstract ideas or laws of nature. So what we have found in the last 10 years is this tends to be the largest stumbling block. Now, Igor and I could honestly go on for hours and hours about what is eligible and what is not with software, and we'll get into that a little bit when we get to the invention disclosure, but we don't want to spend too much time on that because otherwise that's the only thing that we would cover today. The second issue is your invention new under 35 U.S.C. 102? Now, it's called novelty. Now, honestly, this is such a low bar because it's extremely unlikely that two different solutions or two different inventors at two different times came up with exactly the same solution to exactly the same problem. It is almost never going to be the case where, you know, your invention is already disclosed by somebody else. Where novelty actually comes into play more is when there's some sort of date mismatch, like when you had the same inventor do something, like they wrote a paper for a scientific article and then tried to get a patent on it. Well, clearly it's on the same subject, so then the novelty comes into question. It's not that novelty rejections aren't issued; it's just they're usually easy to deal with. The much more complicated issue is the invention, quote unquote, non-obvious to one of ordinary skill in the art under 35 U.S.C. 103, and in that case, the examiner can use multiple different references, multiple patent applications, multiple published papers to say that as, you know, they could be brought together and those references together can be used as evidence that it would be obvious to one of ordinary skill in the art. And the examiner does that and tries to show a reason that a person of ordinary skill in the art combine these references to establish what the legal term is a prima facie case of obviousness. So Igor was kind enough to prepare a really simple chart for dealing with every type of 103 rejection that you could run into, and here it is. This is as clear as day, right, Igor?
Yeah, it's basically too big to fit on the PowerPoint presentation.
So as I mentioned, we've worked on thousands of cases, and every single one of these issues has been brought up multiple times for us. I would say probably the least likely case would probably have been brought up 30 times for us, and some of the more common ones hundreds of times. But there are so many different facets for what can be obvious that you just, we'd spend all day talking about this chart. So anyone that requests a copy of this presentation, and if you had any particular question about one of these issues, if you either were wondering, what this means, or if you had filed a patent application and how do you overcome it, you could certainly contact us, and we'll get a little bit more in depth there. But this is the obviousness issue, and if you can combine references and how they're combined, that's where a lot of the real grind of becoming a patent attorney is. So to get a patent application, or to get a patent, you have to go through basically two separate processes that run sequentially. So and we'll talk about each step, but they're really two separate processes. The first part is patent preparation, from the time you give us an invention disclosure till we file it. So you submit us an invention disclosure, we do a patentability search, draft optionally a provisional application, and then we draft a non-provisional application. After you file that non-provisional application with the Patent and Trademark Office, then you wait for response from the Patent Office, and they will issue a non-final office action. If you deal with that, then they will issue a final office action if the case is not allowed, and then possibly an advisory action, an appeal, and a continuation. So that's the satellite view of what we're going to talk about. So let's talk about each individual element here. Okay, so the first part, and the reason why there's so much information on this screen is this is the most important part of what the patent attorney needs from the inventors. We need an invention disclosure. And we want, when we get a good invention disclosure, we want flow charts, graphs, equations that show how your invention interacts with the environment to solve a particular problem. We would really like it when you identify what the problem being solved is, and also identify the weaknesses of maybe prior art solutions to that same problem, and how your invention overcomes those problems. And we also like to see is, what's the minimum number of parts needed to do your invention? Like, what are all the alternative approaches that you can do? And since we deal so much with software applications, just kind of for fun, we're going to show you by way of analogy here. Let me see if I can get this started. A Rube Goldberg machine. So while this is running, I'll just talk. What we see a lot of when it comes to software patents is, they'll have an invention and they'll just have, the different modules used to implement the invention. And the way that we like to think of those is like pieces of a puzzle. Those modules sometimes are working in the way that they're meant to be worked in. Those type of situations tend to be a lot harder to get patented. So the way I like to think of it is a Rube Goldberg machine, where you have these, like in this case, these Pokeballs and dominoes, and almost a bowling ball that comes in, and these cups and knocks it over. Like, all of these things that are not meant to work together are forced to work together because of the sweat of the person that designed this. So if you take nothing away from this entire presentation, think about, where were your pain points? Being able to drop a ball in order to cause all of this stuff to happen, like we're showing in this this ridiculous example, is the very essence of invention. You know, anybody can get together and make something work that is designed to work, is designed to work in a specific manner. But being able to force pieces together that aren't meant to work together, that's where invention is. So as an example of that, when I was thinking, a simple example is a few years back, I worked on a patent application that was for transmitting a free space optical signal between two buildings. Now, and the buildings were in Los Angeles. And so the problem they were having was as the pollution changes on a minute-to-minute basis, the free space optical signal kept losing the signal partially, and then, in other times of the day was a perfect signal. And so they never knew how much bandwidth that free space optical signal was providing. So, and they couldn't find a good way to optimize the throughput of that signal. So after some finagling, they actually found that if they encapsulated the packets in other, so there were TCP/IP packets that were actually encapsulated in other TCP/IP packets, and those encapsulated packets were actually they actually used a congestion algorithm to decide when those encapsulated packets went across that link. And so they were using something that was really for, the congestion algorithm is normally used for when you have a bunch of competing packets for the same server. So using that in order to optimize a free space optical link, that was basically repurposing something and using it and getting a benefit in an unexpected way. So we were able to get the patent application. So when you prepare an invention disclosure, and again, that's the most important part the inventors do, those are the type of issues that we want you guys to think about. So after you give us the invention disclosure, now this is also an optional, but we recommend this approach. The law firm will do a patentability search. So what does that mean? It means we actually go and look in databases, both like for printed publications like Google Scholar, as well as patent applications, and try to see what are the closest things out there relative to the stuff in the invention disclosure. We want to see, what the examiner is likely to find if you file a patent application on this issue. And honestly, what we have found, and I think Igor would probably agree, is a lot of times this is very helpful because we think we found the invention. Like when we do the search, and we think that it's there, but then the inventors come back and then they tell us, oh, we've misinterpreted something, or they give us more details that really help us distinguish over the art. Is it kind of your experience too? Yeah, this is rarely a roadblock to patents, but it does really help us give a better quality application to the inventors. So
as Mike mentioned, like with the patentability search, the provisional application step is also optional. So I guess the first thing we should probably all agree on that there's no provisional, essentially, patent. It's a provisional patent application. It's basically another way of saying, hey, here's a description of my invention. I'm going to file it, I guess, on the desk at the patent office, and it's not going to publish. It will publish if you decide to claim priority to it and basically file a non-provisional application within 12 months. However, you have to do it within 12 months to get the date that you filed it at the patent office based on the provisional application. The provisional application is probably, I would say that, Mike, you probably agree, is the go-to route for like a startup or, or a single inventor. Just kind of just gives you the time. You buy time, essentially, the 12 months to get maybe, hey, more funding, or, hey, I need to develop the invention a little further. And, it allows you that, way to do that. However, you also have to consider that you have to provide enough disclosure in the provisional patent application. So it's a balancing act because let's say if you don't provide enough information how something works, if there's somebody else invents something and publishes it during that time frame between the date the provisional patent application was filed and the non-provisional was filed, it can be used as prior art against you. So Generally, the best practice is to disclose as much as possible, because even if you don't go forward with the provisional application, it doesn't get published, so there's essentially no harm, no foul in this situation.
And to add to that, one of the more attractive things for startups is that there is no form required for a provisional patent application. Like, it's, we've seen everything from PowerPoint presentations to some random code descriptions being filed with a provisional application, and all of those are accepted because they're not examined. The non-provisional, which we'll talk about more, that has a bunch of statutory requirements, but the provisional, as long as the information's there in some by hook or by crook, it counts. So,
like Mike mentioned, so the next step, if you decide to file the provisional and then 12 months later you have to file the non-provisional, or you decide to file just the non-provisional right away, is the non-provisional has to be, essentially there's a form to it. So the way it kind of flows is you initially have the little bit of background discussion, hey, this is what the current prior art is, and then you provide a summary of the invention, and then you dive into the detailed description. Included in that, you also have to include drawings to provide support for what is the claims goes at the end of the patent application. It essentially is kind of the fence that defines your invention. We initially kind of start with the drafting processes, have like an initial call with the inventors, even if we had one for, let's say, the search or the provisional application, because there could have been changes. The art could have uncovered something that, hey, we should probably include this in the application to get around. After that, there's, we write it up. A couple weeks later, the inventors get it. There's some back and forth. We agree on a final copy, and then, we file it and we wait. And you can wait some time. I think Mike would probably agree.
Yeah.
So if anybody'd like to, if anybody has a pending application, the USPTO has basically an estimator when you're going to receive your first office action. Basically tells you, hey, this is when the patent office is going to give you something substantive.
And I want to add, that thing is wildly inaccurate, because I've actually looked at it, and it doesn't even tend to be right. So it's anyone's guess.
Oh.
So that kind of leads us in, but on average, there's 18 to 36 months after you file a patent application before you get your first office action. Now, a first office action can be either an allowance, which is 5% of the time, but 95% of the time, and that's an actual statistic. That's give or take 1%. 95% of the applications are rejected, and the issue that we always get from vendors, well, why would it be rejected? This invention is so great. Well, it's more, let's talk about the 5% of the time when they are allowed. Is that, number one, you might get an allowance if your invention is really complicated. And what happens in those situations, the examiner can't understand it, and eventually can't articulate an argument of why it should be obvious, because they don't even understand it, so they just allow it based on that. The second issue is, a lot of times you get an examiner that's just not really that, great. It doesn't do a real thorough search. They kind of mail it in. Sometimes you see examiners right before they quit will issue a lot of allowances because they get paid a little bit of money for each allowance they make. So there's those. But when I was thinking about this issue, I want you guys to think about, like, getting an allowance on the first action is not always the best thing. Imagine that you got your friend, they're going to sell you their bicycle, and the friend says, make me an offer, and you say, well, I'll give you $100. And the friend says, great. You always kind of feel like, could I have paid less? Did I really get a good bargain? It kind of leaves like you feel like you could have gotten a little bit more if you had argued more. And that's often the case with patent prosecution. If you draft really narrow claims that don't cover a whole lot, like that are so specific, sometimes you get an allowance. Then you're left with the question, could I have gotten more? So sometimes you need that. If you get that negotiation through the office action responses, you can get broader claims. So that leads into, of course, then the next part is when you get that a non-final office action. And as I noted, the most common, if it's software, is 101 and then 103. Is it eligible for a patent application, and is it non-obvious? And when you read through the the rejection, you see, the reasons that the examiner is contending, let's just stick with obviousness of why it's not obvious over a couple of references. And sometimes we find that we're just talking different languages. And there was a case that I dealt with where we were literally, it was a networking case, and we were talking about tracking the flight path of packets. And the examiner used a reference that was literally a flight path for an airplane. We were obviously having an apples and oranges discussion there. And really, if we tried to put that on paper, that wouldn't have gone over very well. So kind of like a dirty secret of the patent office is that the examiner is instructed not to actually read the patent application. They go right to the claims. And in that case, they might not understand the context of your invention. So a lot of times the interview allows us to provide that context. And the other thing that it allows us to do is to discuss the proposed amendments that would overcome the rejection. And why that's important is not only do we get a knowledge of, will these amendments overcome it, but sometimes, not all the time, but sometimes the examiner can actually predict, okay, they say, yeah, that particular amendment would overcome the rejection, but I know of 3 references that are going to show that exact feature. So kind of a really strange case that happened to me about 10 years ago was I was dealing with an optical communications device. It was a laser, and we were projecting the laser through a medium that was like a mixture that provided a particular index of refraction. And the examiner, and this actually happened, it's so strange, the examiner cited a case that was a surgical procedure for someone's bowels and was referring to the index of refraction of the material in the bowels. So yes, so the examiner was trying to assert that there was a known index of refraction of the fecal matter in the bowels. That was really, really strange. But when we did the interview with the examiner, the first thing is the examiner acknowledged that he should not have issued that rejection. But he did emphasize that we couldn't just specify that we had an index of refraction because he knew of, again, like 3 references that had that feature. So we had to provide more information than that in our proposed response in order to move the case forward. So if you overcome a rejection, now the examiner then updates their search, and they can either allow the case or issue a new rejection. And if they issue a new rejection where they've updated the search, the next office action will be a final office action. And the question is, what does final mean? It sounds like it's really, we can't go forward anymore. I want you guys to think of final means final for your past funds. You haven't paid enough money to continue prosecution at this point. So what they really want is they want a request for continued examination fee, an RCE fee, where you can make more amendments, and then they would issue, if they find a new reference, they would issue a non-final office action, basically starts the process over. This is another time when it's very important to do an examiner's interview, and not just for the same reasons as the first interview you did, because those are still valid, but also one of the things I found is if you insist on an interview for each office action, sometimes the examiner just gets worn out and they get tired of hearing from you, and they'll allow a case simply because they know you're going to hassle them every time. So if you file a response to an office action without an RCE, you can either get an allowance or you can get an advisory action. So the advisory action is a very short office action, and by short, I mean there's usually 2 sentences of substantive material that says you didn't put the application in condition for allowance. That sometimes you present amendments, they say those amendments would overcome the rejection, but they didn't give enough money to do the updated search. So you have to do an RCE, and then they go back to step 4, or they allow the case. The other issue is, you might reach a roadblock where you just can't seem to get on the same page as an examiner, and so you decide that you're going to appeal. And we'll talk about that in a second. But there was a time, I remember once when I got an advisory action where the examiner says, I'll enter your amendment, but they don't overcome the rejection. And I was fine with that because I didn't have to pay the RCE fee. And I knew that the amendments to the claims were enough that I would be able to win on appeal. So sometimes it's useful to get an advisor action simply because you can know, you can get on the same page as the examiner. So that brings us up to the appeals board. Now the first thing is we hope to have as few of these situations as possible. This is not the last resort, but certainly not your first option. So we decide, okay, should you appeal a case is based on a couple of factors. The first thing is, have you reasonably exhausted other options? Normally you file an RCE after you have one RCE, you file an appeal after you filed one RCE. There are exceptions to that, and the exception to that comes to mind was about 8 years ago. I dealt with a case that we did an interview, and the examiner says, okay, that amendment will overcome the rejection. And so we filed a response. And the examiner's final office action says, well, I said that those amendments would probably overcome the rejection. After further consideration, it does not. And there was no other explanation. So I said, well, we should appeal because that examiner negotiated in bad faith. The client disagreed and said, we'll file an RCE. Well, we went through 7 office actions before we reached the point where the client wanted to appeal. As soon as we appealed, the examiner allowed the case without responding. So, that was one of those rare exceptions where, I just knew this examiner was just taking a ridiculous position. That examiner, in the time that 7 office actions was about 4 years, that examiner had 3 different supervisors, which means that 2 supervisors basically moved that examiner to a different art unit simply because they didn't like dealing with them. It's just really hard to get fired, so it's usually what's an indication of. The second reason that you might appeal a case is if you just see an error in logic or whatever, or they didn't give patentable weight to a particular element of a claim. And there was the one case that comes to mind for this is I actually had an examiner assert that a balloon was a quote-unquote rigid member. We were claiming a rigid member, and he said that the balloon was a rigid member. And to add insult to injury, this examiner said that the balloon was a rigid member, especially in the uninsulated condition. I mean, we're never going to see eye to eye on that, right? That's ridiculous. So you appeal, and once again, once it got in front of the appeal board, we won that case. And then the third issue, and this is an issue, is the examiner reading the claims too broadly? And in my experience, telling an examiner that they're reading a claim too broadly is something they're not going to buy. You almost always are going to have to add more features to the claim. You have to amend the claims to get them to read it more narrowly, whereas in front of the appeals board, they're much more reasonable. A few years back, I dealt with a case that the examiner was saying that we were claiming a sensor in a crush zone for an airbag deployment system, and the examiner said that the entire car was a crush zone. The way we had written it was the crush zone was in the front or the back of the car, but the examiner had a sensor that was on the side of the car, and typically the industry standard is that side of the car is reinforced, not a crush zone. But once again, the examiner effectively, when we looked at it, was saying that the entire car was a crush zone, and that was just something we weren't going to ever, see eye to eye on. And the court of appeals agreed with us. There was another time, and this was the very first case I ever interviewed. That sticks out in my mind. Where it was a heart stent replacement case where what our claim was a substantially linear path for this probe that would go into your heart and then place the stent in an artery. And we were claiming, again, a substantially linear path, meaning, you could have a little bit of movement, but it was one direction. The examiner actually cited a reference that had two different cuts in the heart, that one came in and dropped the stent, and then another probe came in and put the stent in the right spot. So it was actually requiring the stent to make a right turn, a 90-degree turn. I'm like, that's not substantially linear. Well, that substantially linear means anything. Once again, we just weren't going to ever see eye to eye. So there are those times, when the examiner's just reading the claim too broadly, that you really need a second set of eyes. Now, what we hope for everyone ultimately is, if you don't get the case go abandoned, that's the downside if you can't get a patent application. But if you do get a patent application, honestly, even if it does go abandoned, you have the decision. If you get a patent issued, do you want to file a continuation application? So the issue with a continuation application is you file the same specification that you did in the previous case, called the parent case, and you file new claims. So there's so you're trying to cover either broader or a different embodiment than you already had. And so what the decision-making process there is, did the patent that issue, did it cover your actual commercial invention? Did it take a left turn somewhere that you ended up adding an element to get the case allowed that, well, you really wouldn't do it that way in the real world? And so that time you'd file a continuation application. You also have the situation where, as I mentioned, some of the ridiculous cases that we dealt with, we had to make amendments that weren't really germane to the actual, most important patentable elements. And so you almost need a clean set of claims. In that case, you're just going for, you basically start with the original claims that you filed in the parent application and add only the subject matter that ultimately led to an allowance. And that's a good way of broadening the claims. And then the third big reason that we see a lot is sometimes ahead of time that you have what we call a rich specification or an omnibus patent application that covers 50 different ways of doing it. It might be 100 pages of patent application, and ahead of time you're going to file multiple patents applications off this one specification. So sometimes it's a strategy decision, and you want to keep going. So the disadvantage of getting multiple patents is now you have to pay multiple maintenance fees once you get them issued, and it is more costly. But the advantage is it improves the chances that the patent will be enforceable, because if you assert a patent in a court for a case of infringement, almost invariably the defendant will assert that the patent is invalid for some reason, and but each patent has to by itself be proved invalid. So the more patents that you have, the less likely that all of them are going to be invalid.
Thanks, Mike. So now we're going to transition to talking a little about foreign patents. So there's essentially two routes or two ways to go about it. There's the PCT route, which is basically going via the Patent Cooperation Treaty, or the direct patent application route. So to understand the PCT route, I think maybe we probably should talk a little bit about the direct route. So the direct route is basically you file directly in the countries. So it's similar, for example, if you're going to only file in the U.S., you would just file it directly with the U.S. Patent Office. Or if you're going to file in Europe, you file directly with the European Patent Office. If you're going to be filing in multiple jurisdictions, you got to be aware of timing requirements, so you don't file in one office and then you file too late in the other office, and then your other's office patent application is prior against your own. So now, regarding the PCT application route, essentially it's a placeholder. That's probably the best way to think about it. It's a placeholder that kind of solidifies your spot with respect to time, and it gives you some period of up to 30 months to make a decision in which countries, hey, do I want to file actually direct application. So if you would file a patent PCT application, and then you'd file the direct applications, which is kind of similar to how I explained before. The nice thing about doing the PCT application is you get essentially a search, and it allows you to make amendments. So one of the advantages of this is we usually don't make amendments, but however we find something that's like dead on, we'll amend the claims, because it'll expedite prosecution when it goes into the national stage. And national stage means, in that direct country that we're going to be trying to obtain a patent in. PCT is basically, like I said, it's just an extension of time. It's a smart move if you are, seeking funding or you want to have additional time to make a decision which countries you want to file in.
So after you file the PCT, then you enter the national phase or national stage case. And so that, like, let's say you file the PCT application and now you've decided you're going to file in Europe, Japan, and Canada. Those are the three most common, but we see a lot of people also file in China. That's probably the fourth largest. And the way it works is if you file directly, each one of those jurisdictions will do their own search, and you'll have to deal with them. If you file with the PCT, different jurisdictions have different rules of how they deal with the PCT applications. So like in Europe, because typically if you file a PCT case, it was a European examiner that wrote the international search report. When you file in Europe, they will just refer to the international search report and say, well, respond to that. Like as Igor said, you don't have to respond to the international search report. And most of the time you don't, but you do have to respond to it when the European examiner says, well, now you got to respond to the European or to the international search report. And then one of the things is that some jurisdictions have is kind of a reverse of what we're showing here is so a lot of you might work with inventors that are in India, because I know this is a very common and ripe area for patent ideas, is sometimes you have to get a foreign filing license. So like if your inventors are in India for an invention, and you want to get a patent in the United States, you'll have to get permission from India to file it in the US. We actually require the opposite. If you want to get a patent in India on a US inventor, for a US inventor, you actually have to file it in the United States first. So there's some international laws that get kind of complicated. And as you see here, one of the things is there's a different process for the European patent process, and we'll take a minute to just talk about that real quick. The first thing is you have the European Patent Office will examine an application, and they have some of the best, I'd say the best patent examiners in the world. Most of them have more experience than U.S. examiners, and they're just expected to be very thorough in their search. The interesting thing with the European case is there's no actual European patent, but if the European Patent Office says we're going to pass this to grant, then you can pick any jurisdiction in Europe that follows this EPO guidelines, and they are contractually obligated to issue a patent to you. Now you could just, like we have the three most common countries are the UK, Germany, and France, and you can file directly in those patent offices as well. But you might end up with, if you do that approach, you might end up with three different patent applications, or ultimately three different patents that issue, because they're going to examine it different ways. The advantage with the EPO process is that you end up with the exact same patent application in all the different jurisdictions in Europe. So it's a nice convenience to have. And like I said, the EPO is a very well-run organization, and they can sometimes give you guidance on how you can work with other jurisdictions. So if you consider any country at all, I'd almost always recommend you at least consider filing in the EPO. So that comes in the end of what we have. It looks like we have a few minutes for questions. Caroline, do we have any questions? I can't see any on my screen, but hopefully some people had some things to ask.
Absolutely. Great presentation, guys. We have a couple questions here. This one is from Justin. Justin is an undergrad studying biomedical engineering, and his goal is to eventually become a patent attorney. He understands that EE is one of the best fields for IP, and he's wondering what you thought of the demand or job market for opportunities in biomed.
Well, the short answer is biomed by itself is great. It's a great opportunity for people with that background. Honestly, what Igor and I end up having to do with our double E background is we will do patent applications directed at like sensors or stuff that are implanted that really are focused on the electrical side of the invention. But when it comes to like organic chemistry or the interaction with the cells, that's where the biomed major is really going to have an advantage over our experience. And sometimes when particular markers or something in a DNA strand that I've seen, those type of situations, we would hand those to some sort of biomed major. Justin, if you want to contact us separately, Igor and I would be happy to talk to you more about the career in patent law. And also we don't know when this will be with the travel restrictions, but the next time that if we're ever in your area, I don't know if you're in North Carolina or DC or somewhere else, if we're in the local area, we'd be happy to meet with you and talk about the career path, and because biomed is an excellent portal to a career field in patent law. So
very kind, thank you, Michael. The next question is there a name for the hierarchy of invention domains of problem spaces to which an invention belongs?
Could you repeat that question?
Absolutely. Is there a name for the hierarchy of invention domains of problem spaces to which an invention belongs? For context, go ahead.
Oh, the genus species is the way that's usually the hierarchy. So the way, at least that's how the Patent and Trademark Office categorizes them. So the simple example is a genus is power generation, and then a power provider, and then a species would be battery. And then there's species under that of, is it a rechargeable battery, so that's the hierarchy. It's almost always referred to as a genus or a species by the Patent and Trademark Office.
Great, thank you. The next question is an assembly / combination of otherwise common elements that innovatively solves a problem patentable?
Okay, remember the Rube Goldberg machine? That's that exact answer. Because that question, and I certainly hope that everyone comes away understanding the answer to that question, is that if you have pieces of software that are meant to work together in a particular way, and you make them work together in that particular way, that typically is not going to be patentable, because that's the very utility that they're designed to do, and that's what I mentioned, pieces of a puzzle. Somebody putting together a puzzle, you don't find videos on the internet of people putting together puzzles. I'm sure that you can find them if you search. I'm not going to watch one, but you will find lots of videos like the one we showed of a Rube Goldberg machine, because you have repurposed elements put together and they do something that the original designer didn't expect them to do. And it is, honestly, that's the number one area for software patents. Sometimes the easy cases are when you have a 5% improvement in a Boolean sort or a search or something like that. Those are easy to patent. Don't get me wrong, but those are the more rare times. Most of the times of the cases that Igor and I work on are when you'll be taking off-the-shelf software parts and rearranging them and getting them to communicate in a new way and solving a problem that the original like API designers didn't anticipate. So that's a great question, but that is the most fundamental question to patent eligibility in 101, because those difficulties that you have in assembling those new parts, that's the technical innovation. That moves it out of the abstract world and into the realm of engineering and forcing things to work together that aren't intended to work together. Do you agree with that?
Yeah, I was going to just say that it's more of thinking, like we talk about the aha moments, where if you've been working in this field for so long, it usually sticks out. You're like, aha, this is unique. They haven't been essentially combined in this way. So that's kind of another way I would probably think about it, is it's like that aha moment.
Be able to articulate what that is,
Great, thanks guys. The next question here is from Miriam. Miriam is looking to file a design patent. After researching where to start, looking through the USPTO and blogs, Miriam has come to understand that she may need to define her own terminology. Could you provide some advice on what the process would be for that?
Okay, so the short answer is, if you're needing to define terminology, it's unlikely that a design patent is what you need, because with a design patent, as Igor pointed out, with like the design of the Statue of Liberty, the design patent is focused on the picture itself. So sometimes you get fabrics that are designed. I know North Carolina, NC State has that great textile program, and the uniqueness of the pattern and the attractiveness is what you're patenting, not the method for making them. So normally, when you file a design patent, you draw a picture of what you're patenting, and then you claim that picture. So it's very unusual that you would be changing a term to do that, because you just say, the picture in Figure 1 is what you get with a design patent. With a utility patent, though, and of course we'd have to talk with Miriam to see what exactly she was talking about doing. With a utility patent, you absolutely can define your own terms. Now, you don't want to say black is white in a patent application, but it is a well-known and well-used skill that when we say a term like a predetermined runtime error, what does predetermined mean? Like, when, was it known, from all of time, or was it known for a very small slice of time? So those type of situations, we can redefine a particular word to have a more narrow definition or a more specific definition than the normal lexicon would tell you. But at the same time, there's usually a word that already describes what you're talking about, and we usually try to find that word first. And if we can't find that word, then we would use a definition in the specification. So to answer the question more succinctly, is like, it is a possibility, but with a design patent, it's just unlikely, because you just look at the picture and you say that's what we're covering. So because it cannot be functional material that you're covering in a design patent.
Thank you, Michael. And Miriam does have some specific follow-up questions, so we'll make sure that she connects to you and Igor separately.
Wonderful. Yeah, Miriam, we'll be happy to set up a call, and we'll virtually sit down and talk about your issues. And that goes true for anybody that contacts us. We'll be happy to carve out some time to talk with you guys.
Perfect. So helpful. And we'll take one last question here. This one is from Griffin. Griffin wants to know, when in a startup's lifespan should they contact law firms to protect their IP when money is tight / non-existent?
Well, this kind of goes more towards what we talked about in our previous presentation, and I believe also you had another law firm that presented about patents, so that's probably of the forum there where that was talked about a little bit more detail. The answer is, if you can't afford a patent, and you have some valuable intellectual property, you almost can't afford to run a business, because if you have a really good idea and you submit that to, you show that to a company and you don't have any protection, they're like, oh, that's a great idea, let's go do it. That happens all the time, and you can find tons and tons of cases out there where the weed whacker, from 50 years ago, I think somebody stole it from the original inventor. The spring release socket wrench, they got sued for patent infringement or appropriation of ideas. They didn't have a patent from some teenager that had Sears Roebuck had taken it and put it on their tool systems. So the answer if you're low on funds, that's the really good option is to file a provisional patent application. You know, even if you have to file it yourself, you can file it for a couple $100. Even if you partner with a law firm and you provide us with a really good invention disclosure, we can usually do one for about $1,200, which sounds like a lot of money, but anybody that deals in business knows that's not, you know, that's not a great deal of funds, and that will buy you a whole year to see, is this something you can market or not, you know, and after the end of the year, if you still haven't made any money on it and nobody's buying it, well, then you probably don't want to convert it to a non-provisional application. And in that case, you know, you can, you know, go do something else. But you won't, I mean, ultimately, you won't have any protection. If you don't have at least a provisional application and you go show your invention to another company, there's not a whole lot you can do about it. You can argue trade secret if you have a non-disclosure agreement or whatnot, but I can assure you, if you couldn't afford a patent application, you won't be able to afford the litigation required to enforce a trade secret lawsuit, because that's like millions of dollars. So, you know, that would be my advice, to go the provisional patent application route, which is the cheapest option.
Wonderful, great advice. Thank you so much, Michael and Igor, for being here with us today. For those who still have questions that didn't add them to the chat box, I encourage you to reach out to Michael or Igor directly. If you need help reaching out to them, I'd be happy to make an intro for you. And as a reminder, this presentation will be on the Riot YouTube channel. So thanks again, guys. Take care. Stay safe.
Thank you. Yeah, thanks. Hey, thanks for everyone for joining us today. And as Caroline said, if you need to reach out to us, please feel free to do so. And even if you're not, even if you have another law firm that's representing you and you just want a copy of the presentation, just let us know and we'll be happy to send that to you as well. So everyone have a great 4th of July.
Take care.
Take care.
Thanks, guys. Bye.
Bye. Bye.